Schiraldi, and I'm a First Amendment attorney at Mountain States Legal Foundation, and I'm joined by my colleague, Erin Earhart, another First Amendment attorney at Mountain States Legal Foundation. We are really excited to talk to you about the Kennedy versus Bremerton School District case. The Supreme Court handed down an opinion on this case yesterday, so this is breaking news. We care about this case because we wrote an amicus brief in favor of Coach Kennedy and his right to pray at the 50-yard line after football games. And we wanted to just dive into the case, talk about what Justice Gorsuch had to say, what the majority had to say about this case. We were not quoted, unfortunately, in the case, but that's okay. So this was a 6-3 decision. Justice Gorsuch, like I said before, delivered the opinion. There were 2 concurrences by Justice Alito and Justice Thomas. They were very short. There was 1 dissent authored by Justice Sotomayor and joined by Justices Kagan and Breyer. And the holding was that the free exercise and free speech clauses of the First Amendment protect an individual engaging in a personal religious observance from government reprisal. The Constitution neither mandates nor permits the government to suppress such religious expression. So Erin is going to tell us the facts about this case before we dive into the substantive analysis.
All right. So Coach Joseph Kennedy was a coach at Bremerton High School, which is outside of Seattle, Washington, for 7 years. He was the assistant football coach. He's a former Marine and a devout Christian. And he felt called by God to pray following every game, win or lose, at the 50-yard line, just briefly for 30 seconds or so, to thank God for the safety of the players and the sportsmanship and the spirited competition that they'd had. And at first he would pray alone, but over time, students and others, both from his team and the opposing teams, would voluntarily join him on the field. And eventually the school district, I guess, learned about his prayer, saw the prayer, and decided that it wasn't okay and told him to cease and desist praying following the game with the students. And Kennedy stopped praying with students, but he sought an accommodation to keep being allowed to pray on the 50-yard line by himself. The school wouldn't let him pray on the 50-yard line, but said that they would let him pray somewhere hidden. Kennedy wasn't okay with that, so he decided to go back to the 50-yard line.
They gave him the press box as an option, right? They said you can go pray in the confines of the press box.
Yeah, they basically said you can go hide and pray, but you can't do it anywhere where you might possibly be seen by students, even if the students aren't joining you. And there was a bunch of other kind of conduct. He'd originally given motivational speeches to the students that included some religious content. Some of this stuff had predated his time at the school, but in response to the school district's objection, he stopped all of that, stopped including religious content in his motivational speeches. And as Justice Gorsuch noted in his opinion, the district disciplined him only for his decision to persist in praying quietly with players after several games in October of 2015, not for any of the extra conduct that might have been discussed in the media or by the dissent. It was only for these brief, quiet prayers at the 50-yard line. And ultimately, Coach Kennedy was disciplined and then asked not to return to the school for the next season. And so he sued in federal court, alleging that the school district violated his free speech and free exercise rights under the First Amendment of the U.S. Constitution. The school, for its part, disagreed, saying that they had to do what they did in order to avoid violating the Establishment Clause of the First Amendment. And the District Court and the Ninth Circuit Court of Appeals both agreed with the school district. So Coach Kennedy appealed to the Supreme Court, which is where we are today.
I find myself doing the same thing. I've almost called him Justice Kennedy multiple times.
It's difficult sometimes.
It is. So in this opinion, the first portion of the opinion discusses the free exercise clause. So just to give everybody a refresher, the free exercise clause reads that Congress shall make no law prohibiting the free exercise of religion. This is applicable to the states through the 14th Amendment. And Coach Kennedy bears the burden to demonstrate that his free exercise rights were infringed. And the way that he can do that is to show that the school's policy was not neutral or generally applicable. Now, if he is able to meet this burden, carry this burden, then the burden shifts to the school to justify that its actions were narrowly tailored. To show that the school's policy was not neutral was pretty easy. The school prohibited any overt religious actions by Coach Kennedy, and it even admitted that its policies were not neutral. So that was pretty easy to satisfy. As far as the general applicability prong factor, whatever you want to call it, the policy wasn't the policy that Coach Kennedy was fired for was that he failed to supervise students after games while he was praying. Now, keep in mind, these prayers are 30 seconds to 60 seconds long. And after games, the other coaches are perhaps making phone calls to spouses or talking with friends or talking with family. So if this rule was generally applicable, all of the coaches would be fired for failing to supervise after games. So what Justice Gorsuch said was that the post-game supervisory requirements were not applied even-handedly, and Coach Kennedy met his burden, proving that his free exercise rights were violated. So the next section of the opinion discusses free speech, and Erin will talk to us about that.
All right. So when it comes to the interplay of free speech, it's particularly interesting when it comes to government employees, which includes public school employees, in which case the Supreme Court has articulated a two-pronged test to decide whether the speech is protected by the First Amendment or not. As a reminder, it's been long established that teachers and students do not shed their First Amendment rights at the schoolhouse gate. That's from a case, I think, in the 60s. That's been a long established precedent. So instead, they do this balancing test. It's called the Pickering-Connick balancing test after a few old Supreme Court cases. First, they ask, what's the nature of the speech at issue? Was it made pursuant to an employee's official duties? And second, they balance the interests of the speech against the consequences of the speech. And so Justice Gorsuch's opinion found that when Coach Kennedy prayed, he was engaged in private speech, not government speech. The prayer was not part of his duties as a coach. It wasn't directed at the players or intended to convey a government message. And as Caitlin just said, it happened at a time when the coaches were allowed to engage briefly in other activities like taking phone calls or saying hi to friends and family, et cetera. So the told otherwise, the Supreme Court said would give credence to excessively broad job descriptions that would treat every religious expression as contraband in the workplace, as government speech subject to government control. For instance, a Muslim teacher would not be able to could be fired for wearing a headscarf to school, or a Christian teacher could be fired for praying over their lunch, or a Jewish teacher for wearing a yarmulke. And this would treat speech or religious expression rather as second-class speech and eviscerate this court's repeated promise that teachers do not shed their First Amendment rights at the schoolhouse gate. So they found that this was protected private speech. Notably, Justice Kavanaugh signed on to the majority opinion, except for this little portion analyzing free speech. He didn't write a concurrence, though, so we don't know why he didn't sign on to this one little portion. I would love to know what his thoughts are on that.
I know. I wish there was at least a footnote or something that said why he didn't.
Could have done what Alito did and read a one-paragraph concurrence, just telling us why, but he didn't.
We will never know. So after the free speech section, what Justice Gorsuch does is he says, okay, Coach Kennedy has satisfied the burden under free speech and free exercise. Now the burden must shift back to the school, and the school can't sustain its burden under strict scrutiny or even intermediate scrutiny. And in this section, he also discusses the Establishment Clause. So in pertinent part, the First Amendment says that Congress shall make no law respecting an establishment of religion, that's the Establishment Clause, or prohibiting the free exercise thereof, that's a free exercise clause, or abridging the freedom of speech. The free speech clause is pretty self-explanatory. And the school said that it fired Coach Kennedy because it was worried about an establishment clause violation. But Justice Gorsuch says that the First Amendment clauses have, quote, complementary purposes, not warring ones. And this was really interesting. One of the best quotes, the best parts of the opinion says that the school district essentially wedged itself between the First Amendment clauses and, quote, then chose its preferred way out of its self-imposed trap, end quote. I thought that was one of the best quotes. And what Justice Gorsuch says is that the school district used an offshoot of the Lemon test, which asks if a reasonable observer would consider the government's challenge to action an endorsement of religion. So that's otherwise known as the endorsement test. And Justice Gorsuch reprimanded the Ninth Circuit for using that long dead balancing test from Lemon and the endorsement test, and saying that that test has been dead for some time, and really instructed courts to look at the Establishment Clause through a historical lens. And it is important to note that history says that the government cannot make a religious observance compulsory. So Aaron and I discussed this in length in our amicus brief, if you care to read it, talking about the history of the Establishment Clause. The whole point is so that American citizens would not be forced to pay for a national religion. So that is important. And Justice Gorsuch notes that through a historical lens, that's how the Establishment Clause needs to be viewed. But he said that the school district was wrong when it thought that Kennedy's private prayers crossed the line into impermissible government coercion. So the school district even admitted that there was no evidence that students were coerced to pray with Coach Kennedy. Gorsuch even discusses really longstanding Supreme Court precedent, other cases, such as the case where prayers were offered over the intercom at a school football game, and the court said you can't do that. That violates the Establishment Clause, and that this case was nothing like it. He says, quote, offense does not equate to coercion. So I thought that was a really good quote. And Gorsuch was really worried that the school thinks that it must remove all religious expression engaged in by teachers in order to conform to the Constitution. So just like Aaron said before, this means that teachers could be fired for praying over their lunch, or wearing headscarf, or wearing a yarmulke, etc. Now, the Supreme Court reversed the Ninth Circuit's decision, and one of the best closing quotes that Justice Gorsuch offered was that there is only the mere shadow of a conflict, a false choice premised on a misconstruction of the Establishment Clause. And in no world may a government entity's concerns about phantom constitutional violations justify actual violations of an individual's First Amendment rights. So although this was a really short opinion, it was very punchy. There were a lot of really notable and quotable quotes. So that was one of them. And that was the end of the opinion. And Aaron's going to walk us through the concurrence and both concurrences and the dissent.
All right, so there were two concurrences. Both were really short. One was about a page and a half, and Justice Alito's was one paragraph. So Justice Thomas concurred with the majority's holding, but found that the court didn't resolve two issues related to the free exercise claim. Number one, the court didn't decide whether or how a public employee's free exercise rights might differ from the free exercise rights of the general public, particularly in light of the history and tradition of the free exercise clause. And second, the court didn't decide what burden or test a government employer might be subject to with regard to an employee's religious expression. For instance, the interest balancing test we mentioned earlier applies to public employee free speech claims, but it's never been applied to free exercise claims. So the burden or test might be different depending on which First Amendment guarantee applies to the employee's speech. Thomas didn't attempt to answer these questions. He just kind of pointed them out. And then Justice Alito, as I said, wrote a 1-paragraph concurrence, making it clear that he joined the majority's opinion in full, on the understanding that they didn't find that a certain standard or burden or test applied to Kennedy's expression under the free speech clause, but only that the school's retaliation to his expression was not justified under any of the standards that the court discussed. So basically,
maybe Thomas didn't write such a long concurrence because he was too busy writing the Second Amendment opinion.
Yeah, right. We got lucky. Some of our colleagues had very long opinions to read for their webinars. Ours was about half the length of some of the others. But basically, both Thomas and Alito agree with the court's decision, but expressed concerns or uncertainty regarding what constitutional interest balancing tests should be applied and to which First Amendment guarantees, concerns that the majority did not address or resolve. So then Justice Sotomayor wrote the dissent, and she was joined by the other 2 liberal justices, Justices Breyer and Kagan. And they found that the majority's opinion, the majority's decision, favored the free exercise clause and gave short shrift, in their words, to the Establishment Clause's prohibition on state establishment of religion. They focused a lot on the potential for coercion to the students, which the majority opinion did address and said was basically hearsay or just kind of speculation that the students might have been coerced. There wasn't really evidence presented that the students were actually coerced. And this was actually a big focus in the oral arguments. All the justices asked a lot of questions about coercion and what might constitute coercion and whether that existed in this case. The dissent also focused a lot on the other conduct of Coach Kennedy, like the motivational speeches, like the religious conduct and content in some of those, that he stopped doing once the school asked him to, and that the majority kind of noted but said, again, the district only fired him for these brief prayers at the 50-yard line, and because that's what he was fired for, we're not going to worry about the other conduct.
The dissent was essentially like reading the Ninth Circuit opinion again.
Yes, it was very similar to the lower court opinion. So the dissent ultimately would have found, like the lower courts, that Coach Kennedy's conduct did constitute an Establishment Clause violation, and that the majority opinion rests on an erroneous understanding of the religion clauses and disregards the balance that previous court decisions have struck between those clauses, basically favoring the Free Exercise Clause and the Free Speech Clause and pushing the Establishment Clause to the side. The dissent also expressed concerns about the history and tradition framework that the court outlines, citing to several of the other cases from this term, including the Second Amendment case, New York State Rifle and Pistol Association, as well as the abortion case, Dobbs, both of which also looked at text as the text of the amendments or of the Constitution as informed by history. That really seems to be a theme of the Supreme Court this current term, and hopefully going forward back to kind of originalist principles of interpretation. The last 2 paragraphs, kind of the conclusion of the dissent, were really interesting, where Justice Sotomayor states that the First Amendment, the Free Exercise Clause of the First Amendment, is a promise from our government that we all have the right to exercise the religion of our choice as we choose. And the second portion of it, the Establishment Clause, erects a backstop that disables our government from breaking the promise of the Free Exercise Clause and starting us down the path to the past where the right to free exercise was routinely abridged. Justice Sotomayor is not necessarily wrong in that statement. It's interesting then that she goes on to say that somehow allowing Coach Kennedy to exercise his religion as promised by the Free Exercise Clause weakens that backstop that is in place to prevent abridging the Free Exercise Clause. So it's kind of in my opinion, a kind of tortured interpretation of that backstop.
I like that. I like that. A tortured interpretation. That's good. That's a good analysis. Well, thank you so much for listening to what we had to say about the Kennedy versus Bremerton School District case. We're very thankful that we got to write an amicus for a case that turned out in favor of the party we wrote an amicus brief for. So that was our first amicus brief that we've authored, and we are looking forward to more Supreme Court victories. Thank you.